Want to know what you can and can't do with your property here in Javea, Spain? In this episode, we sit down with a lawyer to talk about everything that has to do with planning implications, building permits, and much more. So keep on watching. Today we're joined by Rupert Watkins from Watkins Legal. Rupert, it's amazing to have you here. We're going to talk about, well, a lot of things, but especially everything that comes, with buying a property here in Javea in Spain, and then the legal side of things. So it's amazing to have you here with all your knowledge. And can we start off with just, a little introduction about you? So tell a little bit about who you are. What you do.
Well, firstly, thanks ever so much for your invitation. It's a pleasure to be here with you this morning and to hopefully share some knowledge with you. An introduction. Let's see, I'm a British-born but Spanish-educated and qualified lawyer. I'm registered with the Law Society of Alicante, and I've been working in the local area now for more than 20 years. I now have my own firm, Watkins Legal, and mainly I specialise in property transactions, the purchase and sale of property, advising clients, and also inheritance tax and estate planning and processing inheritances. The bulk of clients over the years have been British, but it's over the last 10 years it's been nice to see that people of many different nationalities have realised the benefits of getting detailed legal advice with regard to different issues with regard to property, and not just waiting for transfer of title at the notary's office to actually seek that independent legal guidance.
Yeah, no, exactly. Because there's so many things that come with the process of buying a property. And I think one of these things, people start buying a property, they make an agreement on the price, sign a reservation contract, and that's basically usually when you come into play, right, as a lawyer.
Yes.
Yeah. What is usually the first question I would say people come to you with when they are, at the point of starting this process of buying the property?
Right. Well, obviously, as you say, once buyer and seller have reached an agreement with the assistance of the estate agents, normally we're engaged to do the searches on the property that they have decided to buy. Obviously, here people have different concerns depending on the type of property that they're looking to invest in, whether it's going to be their permanent residence, purely an investment opportunity. And also they ask about, people tend to ask about also the future tax implications of owning the property, passing it on to their beneficiaries. Lately, for example, a lot of people are investing in property with the idea of renting it out to generate an income as investors purely and simply. So therefore, for example, we're getting a lot of inquiries recently about whether it's possible to get a tourist license or not. But basically the idea of the service that we provide is to give them a detailed picture, as it were, of the property that they're buying, its characteristics, the legal implications of buying this property, so that they can make a fully informed decision. And we can actually draw up a private purchase contract to be signed between buyer and seller that reflects potential issues with the property or includes obligations, so that somebody is actually buying what they have seen and what they expect to be buying. So it goes without saying that we will do searches in land registry to establish that the title is duly registered, it's in the name of the seller, there are no encumbrances, charges, restrictions, but it's just as important to do a search in the planning department of the local town hall. There we will find out obviously which planning regulations are applicable to the property, whether there are outstanding issues with the town hall or the developer with regard to the infrastructure, whether the infrastructure has been adopted, and the background of the property, whether the house initially had been issued with planning permission or not, which obviously has a bearing on whether you can renew the licence of occupation and the potential also to maybe extend the property or refurbish it. So all of these are very much this is the information that we would like to give to clients so that they know exactly what they're buying and the implications of buying it. Yeah,
that's a lot of information, and I think it's some sort of common misconception almost, and people, I think at least a few years ago, used to have, buying a property in Spain could be risky because, the land and stuff like that. And I think actually it's really not that bad at all. But also, I think lately everything got a lot more strict when it comes to, how you check once you make the purchase, what you were just saying. You check literally everything. You make sure that before they go to the notary, it's all it's all fine and good, basically.
Yeah, I mean, I think a lot of things, one has to use common sense. It is true that in the last 20 years, for example, since I started practicing and now, the expectancy of clients and what you do as part of a due diligence on a property, there's no comparison to what was done 20 years ago and what is done now. But the principle is that, obviously demands now have changed, but the principle is the same, that if you are guided by professionals, whether it be a lawyer, an architect, an estate agent, if you are guided and you use common sense, you really can't go far wrong.
And I think, of course, that's everywhere, really. It doesn't really matter where you are in the world. Okay, so let's dive a bit into the different types of land you have here in Spain, because that was, I mean, I think that's something that not everybody is aware of, that when you buy, I mean, we could just talk about this area right now, you know, the area of Javea. When you buy, for example, a villa here, you kind of have to be aware of, you know, what the type of land is this villa has been built on, or, you know, if maybe just a plot could be possible too. Can you tell a little bit more about the differences?
Right. Here, people tend to generalize and they refer to urban land and rustic land. From the specific or the technical point of view of planning regulations, we should talk about urban land, land suitable for development, or urbanizable land and non-urbanizable land. Okay, so therefore, in most local areas, the majority of properties, we're going to find that they're within consolidated residential areas, so therefore urban land from the perspective of the planning regulations. There are some areas that are yet to be fully developed. They are deemed to be or classified to be suitable for future development. There, obviously, one has to be conscious of the fact that ultimately there will be a future liability for the infrastructure costs. And then there is non-urbanizable land in which the building of a residential property is actually an exception to the general rule. Non-urbanizable land is not suitable for residential development, and it should be kept as it is for agricultural purposes or with a rustic use. Okay. Within non-urbanizable land, we've got two different types of non-urbanizable land. One, which is non-urbanizable land of special protection, which is really a highly protected area in which normally it is not possible to do anything. And then normal or standard non-urbanizable land, which exceptionally one can get planning permission, say for example, for the building of an individual detached house, but always on a plot of at least 10,000 square meters. Okay, so therefore the current planning statute or regional planning statute that was introduced in 2014 and going back to the mid-1990s, introduced, as I say, the requirement of having at least 10,000 square meters to build a new property on non-urbanizable land, and other such limitations, such as a maximum of 2 floors and a maximum footprint of the build of not more than 2% of the actual surface area of the land. In some areas as well, it is possible to have additional constructions that complement the house as long as there is actually no build above ground level. So therefore this would permit the building, say for example, of a swimming pool, as long as it's not raised. Okay. But again, this depends on the local planning regulations. And again, for example, in Javea, we've just mentioned now that they introduce a cap that even if you have a 40,000 square metre plot, you can never build more than 300 square metres. So therefore, this is an even more restrictive limitation over and above the regional standard, should we say.
Exactly. So each town has their own, what you were saying, their own limitations, basically.
Exactly.
When it comes to, imagine you buy a plot, there's already a villa constructed on it, and I would like to make some changes to that villa, and it's built on a rustic plot.
Right. Here we have to do a bit of research with regard to the background of the property. As I say, from about 1994 onwards, to build a new house on non-urbanizable land, you needed 10,000 square metres. So obviously, if we have a house that was built in accordance with these regulations, in principle, if it hasn't been extended without planning permission, you should be able to get permission to refurbish it. As long as you maintain, normally most town halls ask you to maintain the traditional harmony with the natural surroundings. So therefore, possibly in non-urbanizable land, it is not possible to refurbish a property and to create a very contemporary glass and steel construction that doesn't fit in with its surrounds. Okay. Obviously, not all properties were built after 1994 and on 10,000 square meters. So therefore, there are properties that are 30, 40, even 50 years old that are built on non-urbanizable land and do not have a record of planning permission. They do not have the requirement of the 10,000 square metres, and so therefore they're in a situation that is considered to be incompatible with the current planning regulations. I mean, even in some cases they could have been built in the 1980s with planning permission, but now they're not compatible because they don't have the minimum plot size. Here, possibly the recommendation would be to try and get a legalisation of these properties done. The current regional planning statute permits one to do this, and then once it's on a legal footing, then possibly it is, depending on the local town hall, because there are many different criteria applicable, even though the regional planning statute is the same for the whole of the Valencian community, the interpretation and application of this legislation tends to be very different in different town halls. Mm-hmm. But certainly, if you manage to legalise the property via a procedure that is designed to minimise its environmental impact, at least then you have a legalised property, you have potentially then a licence of occupation for that property, and at least if you want to do internal refurbishments and improvements, I understand that most town halls would interpret that to be possible. But obviously what you cannot do is radically depart from the essential essence of the existing property, and it always has to fit in with its natural surrounds.
Yes, so now we've spoken about non-urbanizable land a lot. Let's dive into the other thing, so the urban land, because of course, I mean that's going to be a lot easier. But also there is some restrictions, right? Like percentages you can build and stuff like that. Can you tell a little bit about that?
Well, therefore, for example, I mean, if we use the typical example of Javea, which is where we're both based, if you have a property that is within urban land, in principle, the first thing that we have to see is whether it was developed after 1990, which was when the current local planning regulations were introduced, or before 1990. If it was developed after 1990, in accordance with a systematic programme of development, the infrastructure has been put in and it's been adopted by the town hall. In principle there, you would normally have a minimum 1,000 square metre plot on which you can build up to 0.2% of roof, so therefore up to 200 square metres, okay? Obviously in the case of these properties, if you're below the 200 square metres, you can extend up to 200 square metres, you can refurbish and modernise these properties, always supposing that they've been built originally with planning permission, and really there are not too many major problems, okay? Potentially what you have to be more careful with, or at least be aware of, are the implications if you buy a property that was built prior to 1990, which was when the local plan was introduced. This tends to be in areas which were not developed in accordance with a structured development project. They were developed on a very haphazard basis, so therefore there's probably a lack of land ceded for public use, for green areas. The roads possibly do not comply with current standards, and so therefore when you apply for a major planning application for properties to refurbish or extend properties such as these, you can be hit with, or certain requirements can be made by the town hall so that you upgrade the infrastructure and comply with current building standards. So therefore, typically, in most residential areas, you would need to ensure that your boundary is adjusted to achieve an 8-metre wide road. For example, you have to put in a pavement and you have to, as I say, upgrade the infrastructure along your boundary, okay? If you're not actually touching structural elements and not extending the property, there is a procedure by which you can, on the basis of what we call a self-assessment or a self-declaration, you can get a minor works permission to do an interior refurbishment without, as I say, touching the structural elements.
Yeah, I think that leads us really good to the next topic I wanted to ask you about, because I mean, the square meterage. We kind of, as estate agents, we notice that sometimes people are a bit confused about, you know, how that's looked at, really, because you have a constructed surface. You know, can you tell a little bit about, you know, what all these numbers include, and also how can you calculate what you could possibly build on after that?
No, I mean, here depending on from which perspective you're looking at build size, obviously there are different criteria. For example, from the point of view possibly of estate agents, well, the size of the house is the size of the house, and therefore if it's 200 square metres, it's 200 square metres. But here we can find that for planning regulations, a house that occupies a footprint of 200 square metres may not necessarily count as being that large for planning purposes. If you have open najas that are open at least on 3 sides, they only count at 50% of their actual roof size. The same with covered terraces. and potentially also with properties that are below or semi-basements that are built on plots with an inclination. So therefore, to determine actual build size for planning permission or for planning purposes, it is essential to get the opinion of an architect, because he will be able to do an exact calculation. For the registration of a title in land registry, obviously an architect probably will base physically any calculations on the size of what they are seeing. So therefore they will not take into account the more specific and involved rules and regulations as for planning purposes. And then of course you have total build size or usable build size, which is obviously the area within the property without counting walls and everything else that actually can be used for living purposes. To complicate things, you may also have the build size in the cadastre, which is the fiscal registry, which may not necessarily bear any relationship to the build size in the land registry or the build size for planning regulations. So I think it is always important when one asks what is the size of a property, is to say, right, for what purpose do you want to know this? To evaluate whether you can make an extension, simply to see whether the build size registered in land registry office is correct, or whether you're paying your taxes in the cadastre correctly or not. As I say, depending on which perspective you're coming from, the answer potentially is different. But yes, I mean, it is important to bear in mind that a 200 square metre build for planning purposes may actually be larger physically, and then for tax purposes you may find that it's classified as being even larger, and this is not something that need to give people any concern. It's because it's different criteria for different purposes.
Exactly. Yeah, because sometimes I think, you know, the swimming pool will be included, for example, in constructed surface, because it will be seen as a constructed, you know, it's constructed.
For example, in the fiscal registry in the cadastre, the authorities will want to charge you for having a swimming pool in the local taxes. But for example, for planning purposes, if you have a swimming pool that is on a flat plot, it is not elevated, it doesn't count. So therefore, this is an illustration of the differences between one system of measurement, as it were, and another, or depending on the purpose.
Exactly. I mean, we're talking a lot about permits today, and I think that's a really good subject, probably something a lot of people have questions about. Another thing we get a lot of times is, you know, people view property, they're really, you know, excited about it, they envision something they can possibly do with it. For what kind of works do you need permits? Because sometimes we get a question, you know, I want to change something in the interior, break out a wall, would that, you know, do you need a license or permit for that?
Right. I mean, basically everything in Spain requires a license, but it is true that since 2014, the authorities or the legislation has tried to simplify procedures. So therefore, we touched before on the consequences of making a major planning application to either extend a property or to carry out a major structural refurbishment. Obviously, this is a very involved planning procedure. It requires a technical project done by an architect and potentially, as we said before, an upgrade of infrastructure. But there are also now much more simplified procedures so that somebody who buys a house built 30 years ago can improve it and modernise it as long as they're not departing from the essential existing fabric or structure of that property. So therefore, the Spanish legislation has introduced a system called a declaración responsable, which is basically a self-assessment sort of declaration by which a simplified procedure by which you can actually make an application simply on the strength maybe of a small technical project, pay the administrative fee, and without having to wait for an answer, you can actually start what you want to do immediately. So therefore, the basic rule there is that, as I say, if you're not touching structural elements, you can do a normal refurbishment of a property on that basis. And it is just simply a case of submitting the application to the town hall, submitting, as I say, something to justify what you're going to do, the cost of it, paying the taxes, and you can then start immediately. Okay? Always without prejudice of the town hall actually investigating in what you're doing, and if your self-declaration is not accurate, stopping the building work. But again, if you play by the rules and comply, in principle, it is to make that application and you can start straight away. So it removes the very long-winded previous procedure of waiting for a license to actually be granted and given to you.
Okay, I think I will try to wrap it up. I have one last question for you, because it's a lot of information, which is really good. So what we also notice sometimes, I mean, we're talking about the 20% at least here in Javea that you can build of, you know, urban plots. what we get as a question sometimes is clients, you imagine 1,000 square meters plot, 200 square meters construction site, so that you're basically done. Imagine if they would like to have a little extra area, to store stuff, or they would like to put a little shed or something like that. Can you tell me a little bit more about that situation?
Let's see. It very much depends on the characteristics of the plot. If you're on a totally flat plot and you've already exhausted 200 square meters, there really I cannot see too many options to legally achieve what you want, even if it is simply to create a storage space. Obviously, if you have a sloping plot, you've got 2 floors, but maybe you have the potential to create a semi-basement that is below the natural lie of the land. Here, potentially, you have the option to create a storage space, obviously not a space that can be used with a residential or as living area of the house, but possibly there you can create an area that would not count for planning purposes and that can be used, as I say, simply for storage, maybe for pump room, machinery, or for installations of the house. Again, the recommendation always would be to speak to an architect, okay, to get a definite opinion, because the last thing that one wants to do is embark on a project, spend the money, and then find afterwards that you have an issue that cannot be legalized, especially if then you're going to come to sell the house and you're going to get people buying in the future who are going to query the legalities of this storage space that is being created. Yeah. Okay. Sometimes people ask whether they can put up wooden structures. My opinion is that if it has a covered roof, it is a solid structure, even if it's made out of wood. Obviously, it counts as well for planning purposes. So therefore, yes, it is. If you've exhausted that 200 square meters, your options, unless you're on a slope and you can maybe create the semi-basement, potentially your options are limited.
Okay, I think the great thing about a wooden structure is that it's easier to take away.
Obviously, yes. If necessary, simply gauge the cost of putting it up and the cost of removing it if necessary.
Exactly. Okay, perfect. Well, I think we will wrap it up with this. Thank you so much for the information. I think
my pleasure.
We could literally talk a few more hours, I think. If you have any more questions for Rupert, I will put his contact details down below in the description. And if you're new to this channel, don't forget to hit the subscribe button to stay up to date with our latest videos.